All right, folks. Welcome to Supplemental Bar Prep for Civ Pro. As the number of students attending the class has dwindled, and I understand that, again, obviously, the afternoon sessions may not work well with your schedule if you have other bar prep obligations going on after your morning session. I figured I would try to mix it up a little bit and try to do something that you can try from home. So in addition to the slideshow, obviously the MBE questions and answers have been included, and then as always, I'm available to sit down and talk and review those with you at any time. 24/7. Again, my cell phone that you have is 413-244-4175. You can text me or call at any time. I'm here to help you get through this thing, and you will. Again, I know it's tough as you're sitting inside studying and you have some beautiful summer days outside. It certainly can be challenging to stay focused, but again, you want this to be the only summer that you are stuck inside studying for the bar. So really put all of your effort into this, get this done and over with so that you can move on, get sworn in, and do some great things as lawyers. And I look forward to welcoming you to the bar as a colleague. A couple of things that I have already mentioned, but just are worth repeating. Part of the bar is really getting your mind and brain healthy and functioning at full speed, and that includes lifestyle, making sure that you're doing what you need to do to be the most effective studier and bar taker you can. So again, I know we've mentioned this before, but making sure you got to get outside, you got to get some exercise, go for walks, take breaks, fresh air. If you have a bike, go on a bike ride. If you don't, jog, walk. If you have an exercise routine, go to the gym. I know every minute of the day is important when you're prepping for the bar, but the exercise component is time well spent. So spending 30, 45 minutes, an hour a day, getting the blood circulating, getting your body moving is really, studies have shown, is going to help you process and retain information a lot easier. So please, make sure that you do that, not just sit in front of a monitor for 12 to 15 hours a day. In addition, eating right. Again, I know it's easy, especially when you're studying and kind of sitting a lot, is to be just grabbing fast food or snacks. Do the best you can, eat healthy. Again, what you put in your body is going to fuel your body and help it be a better and more effective machine in studying. And then last but not least is sleep. So try to get into a consistent sleep pattern. Try to get that 7 to 8 hours that your body needs, that decompression, needs that rest to be able to really absorb going forward. So if you do those three things, if you stick with your commercial bar prep program, don't fall behind, do all the exercises they give you, make sure you're also doing the MPTs and the MEE exercises and getting those graded and getting them back and incorporating those comments into your next assignments, you're going to do fine. You can do this. You got this. You have the intelligence, the skill, the wherewithal. And again, anything I can do to help you, I am here for you. Let me know. So anyway, today we're going to look at civil procedure. So the slideshow, again, I'm going to narrate it a little bit, and then you'll have the opportunity to do the 10 MBE Civ Pro questions. So discovery is certainly an important piece both of the bar and of practice. It's something that if you litigate, you will spend probably more time in the discovery phase and responding to discovery issues than you will in the trial phase. The idea, keeping in mind the big picture, is to find ways to narrow issues. The more that is exchanged between parties, the theory is that it reduces conflict, reduces disagreement, and then there are less things that need to be tried in court. So unless otherwise stipulated, Rule 26 requires parties to disclose certain information to other parties, note, without waiting for a discovery request. So this is automatic discovery. Parties have an obligation to make a reasonable inquiry into the facts and then disclose all the information then available that is not otherwise privileged. So again, parties, if they're served with discovery, just can't respond, I don't know, I don't know, I don't know. They have an obligation to do some inquiry and attempt to respond to the discovery request reasonably. Again, you can't close your eyes and plug your ears and just pretend you don't know anything about your case. So there is that obligation. 3 types of required disclosures. There are initial disclosures, disclosure of expert testimony, and pretrial disclosures. We're going to look at each one of those in the next slide. So initial disclosures, again, without waiting for a discovery request, party must provide to the other parties the following within 14 days of the 26F meeting. So again, looking at another piece of the federal rules, there's a requirement that the parties meet under Rule 26F. After that meeting, you then have 14 days to exchange, 1, the names and addresses and phone numbers of individuals likely to have discoverable information. 2, copies of documents. That includes electronic, in addition to hard copies, in the party's possession, and note the rest of this sentence, or control that support its claims or defenses. So again, if you are responding to discovery at home and they are requesting documents and you don't have those documents at home, but you have them at work, obviously you have an obligation to retrieve the documents and produce those. So within your possession or control, even if that entails you having to do a little bit of legwork to get those documents. Number 3, computation of damages claimed by the disclosing party and copies of materials upon which the complaint computation is based. So for example, a tort claim, again, you're going to need to have the medical bills that will have to be put together to accompany the initial disclosure in order to support your damage claim. And then finally, copies of insurance agreements under which the insurer might be liable. It's important that the insurance companies are notified and brought into the matter early on, and not only might they have an angle on the defense, but they also may get stuck paying. So again, it's a requirement that if there's insurance at play, the parties have to disclose that at the outset. Certainly, it's also important when you are negotiating a settlement. If there's insurance money available, that can certainly change the tone of the settlement. Expert testimony. So a party must disclose the identity of expert witnesses expected to be used at trial. If the expert has been specifically retained to provide expert testimony, the disclosure must be accompanied by a report prepared and signed by the expert stating their qualifications, opinions to be expressed, the basis of the opinions, and a list of cases they have testified in within the last 4 years. So pretty straightforward. If you're hiring an expert, the other side has an opportunity to evaluate that expert and potentially retain or get another counter expert involved in this case. Again, the goal of discovery is to prevent the big courtroom drama scene that you sometimes see on TV where the trial is ongoing and suddenly somebody bursts through the courtroom doors and says, you know, here is the evidence, or here is the report, or here is the surprise witness. Really does not happen because of the federal rules, and this is another example of that. Again, sharing information in advance of litigation so all sides know precisely who is going to be called by the other side. So this is where this rule comes into play. Other pretrial disclosures, at least 30 days before trial, a party must disclose a list of all the witnesses they expect to call, and they have to also include in that list the witnesses they will call if needed. So again, potential impeachment witnesses, but you can designate that in the disclosure. Again, those that you expect are going to be called and those that you may call. And the witnesses whose testimony will be presented by deposition, if any. So again, if a witness is unavailable, You, in some instances, are able to use the deposition. Again, the other side needs to know that at least 30 days before trial. That way, if they're going to object to any of these disclosures, they have time to do that. And documents they expect to offer might be offered if needed. So again, a list of the exhibits or evidence that you intend to present at trial. Again, this is all to take away the component of surprise. The idea is that surprise does not serve justice, and really both sides should be fully aware of what is going to happen at the trial so you can prepare your case accordingly. And again, within 14 days after disclosure, so again, 30 days before trial, party discloses these 4 items. Within 14 days after that disclosure, the party may serve objections. So again, if you object to certain witnesses, if you object to certain witnesses intending to present by deposition, or if you're objecting to certain documents, you can then serve those objections, and the court will hear those before the trial starts. So discovery of electronically stored data, huge area. As more and more data is stored electronically, the courts are trying to deal with how do we fairly allow those involved in litigation access to that electronically stored data without, on the other hand, overburdening the other party with having to pull, could be millions or hundreds of millions of pieces of data or records. So the rules require the parties to discuss the discovery and preservation of electronically stored data. Electronically stored data need not be produced if the responding party identifies it from a source not reasonably accessible because of undue cost or burden. So again, this is that balancing act. If it is going to be exceptionally burdensome or costly, the court will have to weigh that with the probative value or need of that documentation. So electronic stored data discovery issues oftentimes can end up in front of the judge having to make that type of a call. A requesting party may request the form of the electronically stored data, and the responding party must use that form unless it objects. So I'm requesting payroll information from you, and I'd like it in the form of a spreadsheet. I'm able to make that request. If the other side objects, again, the court may then have to determine what form that electronic discovery is presented in. If a form is not requested, so if you just say, I want payroll data, the responding party may use any form in which the information is maintained. So I'm just going to use my normal payroll software printout and provide it to you in that form because you didn't request any other form. So again, in some of these cases, the courts will actually have to appoint a discovery master, which essentially is a magistrate or a third party to help facilitate and oversee some of these discovery disputes. Again, be careful. 37E creates remedies and sanctions for parties that fail to take reasonable steps to preserve electronic data when litigation is reasonably foreseeable. Again, this is certainly an area we're seeing more and more of, is because data is being stored electronically, it's also easy to make that data disappear. Either intentionally or unintentionally. So Rule 37E really is set up to be a little bit of a hammer, an enforcement mechanism to ensure that parties take steps to safeguard the data and not let it disappear. Again, this can be a complex area because many companies might have policies where they purge data after set time periods. However, once that company knows that litigation is reasonably foreseeable, they're going to be required to change that policy as it pertains to the data that's going to be needed for this particular piece of litigation. So again, a big area of dispute, and we're seeing more and more discovery masters having to deal with with these types of issues. But be aware there are sanctions out there if a party does, in fact, not preserve electronically stored data. The scope of discovery. So discovery is very broad. Unless the court limits discovery by order, discovery may be had on any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case, considering the importance of the issues at stake, the amount of controversy, the party's relative access to information, parties' resources, the importance of the discovery in resolving the issue, and whether the burden or expense of the discovery outweighs its benefits. That's a mouthful. I will tell you again, this discovery is broad, and in many instances, discovery does allow one party to engage in a bit of a fishing expedition. It really lets it kind of poke around the exterior of what in fact might be relevant. Now remember, just because you're able to get access to information by discovery doesn't mean it's getting admitted in court. Discovery is different from litigation. So discovery is gathering data, but it still has to go through the evidentiary process in order to be admitted in court. So in many cases, you'll have volumes of discovery, but what actually gets used or is admissible in court is a much smaller subset of that discovery. So discovery is much broader than the rules of evidence that would otherwise allow you to get that information into court. Work product of a party or representative of the party, most likely their lawyer, made in anticipation of litigation, note, is discoverable. I think people mistakenly think, it's work product, never something that would ever have to be disclosed. Generally, that's true, but again, the rule indicates it is discoverable only upon showing substantial need and to avoid undue hardship in obtaining materials in an alternative manner. If required to be disclosed, the court must limit mental impressions, conclusions, legal theories, or opinions. So, for the most part, work product is not something that is discoverable. However, there are circumstances that you may see on the bar exam where, again, you're showing some extreme hardship, undue hardship and substantial needs, so the death of a party, and the only way to get the information is through a request for work product. The court may allow that, but again, even if they do allow it, they will redact other aspects of the work product. So if the lawyer, in addition to having this report, also made comments on the side about their theory or how they're going to use that data, the court will redact all of that. So in general, work product doesn't come in, but again, like many of the federal rules, as you have been studying, there are exceptions to those rules in certain circumstances. Inadvertent disclosure, this is something that, again, because of the volume of discovery that folks are dealing with nowadays, inadvertent disclosure happens more than you might think. If a party inadvertently discloses trial preparation or privileged material to opposing counsel, they may still claim that work product protection or any privilege applies. By notifying the opposing counsel, so you let them know, by accident when I sent you that queue of emails, of the 20,000 emails, email 499 was one that should not have been included, and it was a mistake on our end. It was an inadvertent disclosure. We're letting you know that we continue to claim that work product protection applies to that email. You now, as the opposing party, have an obligation not to use email 499 or disclose the material in email 499, or if you have forwarded email 499 to somebody else, you have to take reasonable steps to retrieve it so that third parties will not be able to use it either. Again, it's tough to unring the bell once that information has gotten out there, but courts recognize, because of the volume of discovery, that it was unfair to the litigant in most cases if the lawyer made a mistake in disclosing something they shouldn't have, so they've created this rule. Experts, a party may depose an expert expected to be called at trial after the report has been provided. So again, there's really two types of experts. You have trial experts, again, those expected to be called at trial, and consulting experts, those of whom you may be working with, but you're not expecting to call them to testify. Trial experts, you have to share their reports in advance of trial, and again, the other party has an opportunity to depose them before trial. Consulting experts, generally not discoverable, so you're generally not entitled to their report. Again, as I said earlier, there's always exceptions, essentially when justice requires. If there are exceptional circumstances, then the court may order consulting experts to produce a report that otherwise would be not discoverable. But in general, the general rule is experts that are being called to trial, their reports do have to be disclosed and they can be deposed. Consulting experts not disclosed, and again, they're not going to testify. A protective order, Rule 26C, again, this is an important sword in the litigation process, in the discovery process. It discusses a protective order, and again, a protective order limits the nature and scope of discovery if it's being abused. So if your client is hit with an overly broad, request for production of documents or interrogatory questions, you can protect your client by going into court under Rule 26C and asking the court to issue a protective order that limits the number of questions or limits the number of documents or limits the scope of the documents. There's no reason in this case that they should be asking questions about my client's mental health when that's not an issue of the case. So you can do certain things to balance the rights of your client with the rights of the opposing party to gather information. That's a Rule 26C protective order. Supplemental disclosures, always remember that again, discovery is going to happen early in the litigation process. However, as time progresses, things change. You are not frozen in time. So if things change over the course of the discovery period, you have an obligation to supplement those responses. So a party must timely supplement required disclosures and prior responses to interrogatories, requests for production, or requests for admissions. If it is learned the material was materially incomplete or incorrect and the new information has not been made known to the other party. So again, as investigations proceed, as more information is uncovered, you have to go back and supplement the discovery that you have already responded to, so that by the time the discovery period is concluded and trial is ready to begin, both parties have the most up-to-date information and they can use that to prepare their cases. Depositions. So a party may not take more than 10 depositions nor depose the same person more than once. Again, please note the conclusion of this sentence, absent leave of court. So you can actually take more than 10 depositions, and you can in fact depose the same person more than once with court permission. But generally, you're limited to 10, and you get one bite at the apple with each person. Deposition may not exceed 1 day of 7 hours. Again, absent leave of court. Under Rule 30, a deposition may be used at trial in lieu of their appearance if the deponent is not available. Deposition may be taken by phone or other remote electronic device and may be recorded by sound and visual, so like a video recording, or stenographic means. Rule 27, under Rule 27, a person may seek a court order to perpetuate testimony. Under Rule 27 procedure, a person who wants to perpetuate testimony about any matter cognizable in the United States court, may, even before the suit has been filed, file a verified petition. So be aware that under Rule 27, there are ways that you can actually take testimony before suit has been filed. So again, typically depositions are happening after the complaint's been filed, after the discovery period has begun. But again, there are exceptions if you have someone who maybe is deathly ill and you need to capture that information before the complaint is filed. Again, Rule 27 allows for that to occur. You do not need a subpoena for parties. All you need to do is send them a notice of deposition. However, non-parties should be subpoenaed. Subpoenaed may be served by anyone who's not a party and over 18 by delivering a copy and the necessary fees to the named person. Can only demand the person to appear if within 100 miles of where they work or live. So if you got a case going in Massachusetts and you need to depose somebody from California, you can't force them to travel here unless they're otherwise normally here on business or have some other reason to be here. In that case, you would have to fly out to California and do your deposition there. So there's a 100-mile window that the court has imposed to make this not too burdensome on the person being deposed. If a properly subpoenaed person does not appear, the court can award costs to the other party. So if you hire the stenographer and you rent a conference room, and again, you've set time aside in your day to take a deposition and you have properly subpoenaed the person to appear and they do not, the consequence of that is the court can order them to pay fees and costs that you've had to incur. Compulsory appearance, again, a subpoena is not needed for parties. As I just said, notice is enough. Non-parties should be subpoenaed, may be served by anyone who's not a party over 18, and a properly subpoenaed person does not appear, the court can award costs. So again, this is essentially what I had said in my last slide. Rule 33, interrogatories. Written interrogatories requires a response not only with the facts they know, but also with those facts available to them. Again, this goes back to the general concept of discovery, is that you can't sit in a room with your eyes closed and your ears blocked. When you are responding to discovery, you have to take reasonable steps to inquire and find what the answer is to the question that's being sought. In the end, if you don't know, you don't know, and you can say that, but you can't basically say you don't know because the information is contained in a document that's in your bank's safe deposit box. You've got to go to your bank's safe deposit box and look at it and then respond accordingly. Initially, only 25 interrogatories may be served without leave of court. Again, note, with interrogatories, a lot of attorneys will ask subparts. So, question 1, part A, question 1, part B, question 1, part C, getting different aspects of information. The 25 interrogatory rule applies to all the subparts as well. So you can't have 25 interrogatories, each with 4 subparts, so you're really asking 100 interrogatories. The total number is 25. Production of physical material. So Rule 34 provides for the production of physical material by a party. It includes documents and electronically stored information relevant to the pending action, and that a party may be required to permit entry onto land for testing. So if the case involves lead paint, then again, Rule 34 is a mechanism that would allow the opposing party to enter that property and test for lead paint, for example. So again, Rule 34, you're thinking about documents that you want to get access to, whether physical or electronic, or your ability to go on to somebody else's property to conduct an investigation. Rule 35 is order for a physical or mental examination. Again, pretty rare. This would only be something that you could utilize if physical or mental examination or their condition is part of the controversy. So again, a serious car accident, and you want to, the insurance company wants to have their doctor take a look at the individual. Rule 35 may allow them to do so. Note that in order to compel a party under Rule 35 to undergo a physical or mental examination, this is one that the court has to approve. So most of the other discovery mechanisms we're talking about are automatic. These are things that you do as part of the normal discovery process. I send out notice of depositions, I send requests for interrogatories, requests for production of documents, requests for admissions. This is one where you've got to go to court and actually get a judge to sign off on before you can engage in the requested behavior. Rule 36, request for admissions. This was always one of my favorite mechanisms in litigation. Any party may serve on any other party a written request for admissions as to the truth or genuineness of any matter or document described in the request. The matter will be considered admitted unless the party on whom the request was served returns a sworn statement denying or explaining they are otherwise unable to admit or deny. So procedurally, this is something that is used a lot. So after I, as the plaintiff, file a complaint and serve it on the defendant and discovery has begun, I may serve the defendant with requests for admissions where I basically repeat the factual allegations in the complaint. So, isn't it true on this day you drove this car at this street? Isn't it true that you operated your motor vehicle in a negligent manner, causing an impact with my client's vehicle? Isn't it true? And basically, you can walk through the complaint because, from a tactical standpoint, if they do not object, if they don't respond to my admissions within 30 days, it is deemed admitted. So if their lawyer's not on the ball and doesn't properly, mark this in their file, most discovery, there's some flexibility with. You can kind of deal with it because discovery typically is a process that can take months and months, if not years. Request for admissions is something that is very timely. So if the other party does not, in fact, respond to the request for admissions, you could essentially then march right into court and seek a summary judgment because, in essence, they've admitted all of the allegations in your complaint. So from a practical standpoint, as a practitioner, you always you need to be very careful with your calendar for anything, obviously, but request for admissions is one that's particularly important because if you miss the deadline to object or oppose, then you have essentially admitted everything that they have laid out in their Rule 36 request for admissions. So just a little side note there of something to be aware of.